here are the learning objectives. We're going to go through them really quickly. We've identified 8. So the first is we're going to talk about all the individual programs, and there are 5 of them. They're listed here on the slide. The second thing we're going to do is we're going to talk about how to qualify for the programs. Then we're going to talk about how you maintain qualification for the programs and you don't run afoul of rules like the affiliation rules that can cause you to move from small to large, sometimes without knowing you've done that. The next thing we'll talk about is how you take those certifications or qualifications, some of them are self-certifying programs, and actually use them to win and perform contracts for the federal government. Then we're going to work on how you team with large businesses as a small business, or how as a large you can team with smalls while complying with all the relevant rules. Next, we'll talk about what happens when a small business is acquired. M&A is an increasingly important subject in this area of law. There's a pretty, I would say, hot M&A market right now for small business government contractors, and I get questions all the time on what happens after you get bought. We're then going to talk about recent and forecasted rule changes. There are many of them, and some of them are actually on President Trump's desk right now. And then the last thing we'll talk about is enforcement. It's kind of the reason why the rest of the rules matter, is that the government is really strongly enforcing these rules and doing so on an increasingly frequent basis. So what folks may know about the SBA rules 5 or 10 years ago, probably it isn't true anymore because of the changing enforcement environment. So this is currently the thing I was talking about earlier being on Trump's desk. Recently, the Senate passed a bill that will change this from an average of the 3 most recently completed fiscal years to now an average of the 5 most recently completed fiscal years. I actually helped draft the bill. It was a long process, a long time in the making. It involved lots of different stakeholders. The purpose of the rule, as I actually testified to Congress on the subject in support of this rule, is to help firms bridge the mid-size gap, is what it's called. There are a lot of small businesses right now in the country, and there are a lot of, or a relatively large number of large businesses, but there aren't a lot between the 2 categories. So by extending the amount of time folks have as small, it's going to increase the number of small businesses and give them a greater amount of time to grow to be large, or to grow to be able to succeed in that full and open large environment. You know, what does it mean to be unconditionally owned? These are areas of, these are questions that Chris and I are often consumed with in our own practice. There's a lot of case law on the subject. There's also a lot of changes to the rules which can sometimes invalidate that case law and require people to rethink about the issue entirely. One area of concern is this idea of rights of first refusal. I don't want to get too much in the weeds about it, but a right of first refusal is essentially when a minority interest holder or the company has the ability to limit how another owner of that company sells his or her shares of the company. And so in this case, if an SDV has a limit on his or her ability to choose the recipient or the buyer of the shares, that is considered to be a condition on their ownership. So rights of first refusal historically have been allowed under the VA rules, not under the SBA rules. Now it's a little bit uncertain because we've got this new set of rules. The courts haven't caught up to interpret these new set of rules. I would say that this is one of the areas that you'll hear us talk about that is complex and subject to further court elucidation. Affiliation is probably the most complicated of all of the likely somewhat already complicated rules we've discussed. So I'm actually going to read this top of this slide because it's very important. Concerns and entities are affiliates of each other when one controls or has the power to control the other, or a third party or parties controls or has the power to control both. It does not matter whether control is exercised so long as the power to control exists. So the consequences for affiliation is that size is aggregated. All right, so the example here, I'll summarize it. If 2 firms or you know, one firm controls another firm, and we have the first firm is 12 million, the second firm is 8 million, both firms will be considered a $20 million a year business. Not either firm, but both firms individually. And so, as the example here says, if either firm is trying to bid on a $15 million size limited contract, neither will be eligible. Identity of interest. It's where firms that have substantial identical business interests are economically dependent on each other. It's a rebuttable presumption. It's one where the best example is firms owned or controlled by immediate family members, so spouses or father-daughter, siblings. If there's two different businesses owned by immediate family members and those businesses do business with each other in any capacity, there will be a presumption of affiliation. The same can be said for firms that derive 70% or more of their receipts from another concern over the past 3 years. They're going to be presumed affiliated. So look for that 70% figure in your firm's bottom line to ensure you're not economically dependent on another company. The next thing we'll talk about is the rule of two, which is we're sort of changing gears right now. Yeah. So imagine you're small, you're not affiliated, you've qualified for the relevant program. How do you now use your status to get work?
Right. So how does this matter? So the government has a preference for awarding contracts to small businesses, as we covered earlier. And the general rule is that contracting officers are required to set aside procurements for small business where there's a reasonable expectation that two or more responsible small business or other socioeconomic program concerns will submit offers, and an award is going to be made at a competitive, fair market price as a result of that. The rule of two is presumed to be met where an acquisition is above what's called the micro purchase threshold and below the simplified acquisition threshold.
The most important SBA-specific rule for contract performance is what's called the limitation on subcontracting clause. And it means that the prime business, the prime contractor, the small business prime contractor, has to perform at least 50% of the contract. Now, this is where it's going to get a little complicated because the calculation for this 50% is changing. It used to be, and it still is at this exact moment, that the prime must perform at least 50% of the cost incurred for personnel with your own employees. So not subcontractors, not independent contractors. The prime has got to perform 50% of the cost incurred for personnel. That is changing to be essentially a true limitation on subcontracting, measured not by the cost incurred for personnel, but by the total value of the contract. So if it's a $10 million contract, the small business prime contractor cannot sub out more than 50% to a large business. But there is an exception. And that exception, of course, is the similarly situated entity exception. So if there is an SDVOSB set-aside contract won by an SDVOSB, that SDVOSB could sub out 80% of the contract if it's subbed to another SDVOSB. So one or more of the relevant type of contractor must perform this at least 50% of the contract. So in theory, they could sub out 50% to a large business, 40% to the other SDVOSB, and then perform 10% itself, and that would be compliant. The mentor protege program, the new one, SBA's all small mentor protege program, actually was just started in October of 2016, so it's just a little over 2 years old now. And it's been very successful. The prior program allowed only 8A businesses to be mentored by large businesses. Now SBA has opened that up to all forms of small businesses, and there are a myriad benefits under these programs. The most important thing to know is that usually when a large business and a small business joint venture together, they are not able to qualify as a small business for small business set-asides, right? Under this program, if your large has been your approved mentor, you as a small business could joint venture with your large mentor, and that joint venture would be considered a small business for set-aside contracts, for 8A sole source contracts, and these joint ventures not only qualify as small, but the large businesses can actually do more than they usually could under the prime sub world, right? So a large business could perform up to 60% of the contract rather than the usual 49% that we talked about a few minutes ago. Now, what is the quid pro quo here, right? The large is getting all these benefits. Well, the quid pro quo is that smalls have to be mentored by the larges. And the mentor-protege agreements that you enter into are very detailed and robust in terms of what kind of assistance must be provided, how frequently it has to be provided, how do you measure success. And SBA will audit these things. In fact, there's an entire office set up just for the purpose of accepting folks into this program and then maintaining their compliance with the program.